Thanks very much for coming back for day 2 of our spring symposium on reforming criminal justice, structural innovations to improve the administration of justice. We had a terrific day yesterday, and I think we have an equally exciting day today, talking about a variety of really key issues in the criminal justice system. But to kick us off, I'd like to once again welcome to the Quattrone Center stage, Penn Law Dean Ted Ruger.
So as I said yesterday morning, I couldn't be prouder of what the Quattrone Center and those who lead it and support it have done over the past several years. The founding vision was always to have a center that produced the highest level research, but that really connected with the highest levels of practice and indeed made a policy impact toward a fairer, more just criminal justice system. And we are seeing that happen. Due to the work of the Quattrone Center, we know that it's going to happen with even greater impact and greater pace going forward, and I really am both very proud of that and pledge to work with you to support it. What we do here is very much an intellectual exercise with the highest levels of methodological rigor, and I'm very proud of the research and discourse that happens under the Quattrone Center's auspices. So it is very much an intellectual exercise, but it is not only an intellectual exercise. It is then connected to the problems and solutions that we find and that we need in the criminal justice system. And again, the center is doing exactly what we hoped it would, and we know it's going to do even more in connecting its research to real-world problems, and then bringing the people in the room and on the agenda yesterday and today coming from the places you are situated in within the criminal justice system and within academia. It's great to convene this, and I do thank those, John Holloway, Paul Heaton, and others who were involved in setting this agenda and building this great conference. This is the other thing that's really palpable to me as I look at all the issues that we deal with at the law school and in our broader public policy space. It's no surprise to anyone that across a lot of issues, we are not talking to each other very well across ideological differences. It's hard to get, I teach health law, it's hard to get any kind of discourse or consensus going across the aisle on how we ought to fix our healthcare system. It's hard to talk about a prudent level of environmental regulation or trade policy or foreign policy these days. But in ways that would have been inconceivable to me when I was in law school in the mid-90s, there's this wonderful inflective moment of inflection where I think we are, where actually people from a wide range of perspectives, political positions, agree that our criminal justice system needs reform. And there's never been more of a kind of coming together toward this common cause, be it people of different political ideologies, be it reform-minded prosecutors together with defense attorneys. So this is not only is the center doing great work, but there couldn't be a better time to address these problems. I think we really do have a chance to make a difference collectively for our justice system throughout the nation. So thank you, and we'll get into this wonderful substantive program today.
Thanks, Ted. So we started yesterday with our conversation on changing structures in criminal justice by talking about interrogations, and in particular, ways to modify and the way that we conduct interrogations that would not only generate more information and therefore supposedly help to solve more cases, but actually, to use interrogation techniques to also expose untruths that might get told in the interrogation process. So both getting more information and getting less untruthful information, both of which are useful if what you want to do is get the right guy in the right way. We moved on from that to Howard Root and his conversation about federal prosecution and some of the misincentives and things, and the immortal line, "Nothing good ever happens in a Holiday Inn in Burbank, California." We've looked at models of defense, the holistic model of defense from the Bronx Defenders and its effectiveness and impact, and a model that involves looking not just at an accused or a perpetrator, but actually at a human being and how we can help that human being and therefore reduce crime and not just enforce the law. And some novel models, Emily Galvin's defense model that would exploit sort of a Teach for America model to extend the reach of holistic defense more broadly to jurisdictions that have budget or other structural challenges in putting that in place. And then we talked about the long tail of criminal records and the collateral consequences that come not just with convictions, but with arrests. And I think it's probably clear to everybody in this room and everybody who's watching online that actually there's no real trick to getting arrested. Anybody can get arrested, and the idea that an arrest, which is not a statement of guilt or a finding of guilt or really even a lot of times anything other than being in the wrong place at the wrong time, is something that could have lifelong consequences on your ability to get a job or get housing or something else. And now we're watching that expand, given the technology of the day, into walking down a street with somebody, getting caught on a database, and then being labeled as a gang member with attendant criminal justice consequences. And so how we deal with the data we are, in the first place, are we gathering the right data, and how do we deal with the data we are gathering are huge. And then we ended the day with a fascinating conversation on the changing role of the prosecutor. We had a representative, the policy representative from the new Philadelphia DA, side by side with the Cook County State's Attorney and other observers of prosecutorial behavior, talking about policy changes and the challenges of implementing them in the real world in a system where nobody operates in a vacuum. We're going to pick up on those themes today, I think, in really interesting ways, because I think what we saw from each of those panels, one of the real key themes and takeaways was we need more data and we need to handle it responsibly. And so the last of our 4 Quattrone fellows that you haven't met yet, Amanda Woog, I think has unique research that she's done in the exploitation and manipulation and use of government and publicly provided data to inform the general public about things, and she's convened a panel to talk about that topic. And then at lunch, we have a really unique opportunity. So the lunch panel, which will be upstairs in the Levy Auditorium, will bring together Keir Bradford Gray, the chief defender in Philadelphia, Commissioner Richard Ross of the Philadelphia Police Department, First Assistant Judge Carolyn Temin of the Philadelphia DA's office, and Councilman Curtis Jones of the Philadelphia City Council. So we'll have a policymaker, well, they're all policymakers, but of course we'll have the city councilman, the DA's office, the defender, and the police all talking together about how do we actually implement this reform at the street level, even when there is a combined willingness to do this. What are the challenges and how do we work together? And to lead into that, I'm really excited to introduce Christopher Stone to talk to us about the changing role of the prosecutor. If you went back a decade ago, I think the role of the prosecutor was very different than what our communities are demanding of it today. And I think many prosecutors would have told you that their job was to enforce the law, not just to, or it was just to enforce the law, and that it has grown into something where we are really expecting our prosecutors to take a vision of reducing crime and doing so in thoughtful ways and a much more utilitarian view and not just a law enforcement view. And Chris was really at the forefront of recognizing how much discretion prosecutors have at the outset of adjudication, with charging, with bail, with plea bargaining, all the way through the process. Prosecutorial discretion is paramount in what we do in criminal justice. But there wasn't just that observation of discretion. I think Chris also recognized that many people in the political process, many voters, didn't think about that discretion in the election of their district attorneys. There are only 3 states that appoint their district attorneys: Alaska, Connecticut, and New Jersey. And in every other state, district attorneys are elected. But until very recently, there really hasn't been a focus on information and making information available to voters to help them differentiate among candidates and elect DAs not just on party lines or on incumbency, but on the quality of their ability to execute on criminal reform. Chris, the Open Society Foundation, and others really have changed that and made DA elections the important civic conversation that they ought to be. And Chris's time as the president of the Open Society Foundation, a global nonprofit that has wide-spanning, Chris, I think there were 30 offices worldwide, something like that. Yeah, a mammoth organization. He's done an incredible amount of good. He was there from 2012 to 2017 and prepared for that with a long experience in criminal justice reform, particularly as director of the Vera Institute for 10 years, and following that up as the Guggenheim Professor of Practice of Criminal Justice at the Harvard Kennedy School from 2005 to 2012. Since his time with the Open Society Foundation, Chris has been traveling around the country looking at prosecutors, meeting with prosecutors, and examining a topic that we've talked about in this room. How do you measure quality in prosecutors' offices? How do you know if you've got a good prosecutor in your jurisdiction? And given his background and the time he spent on it, I think there will be a wealth of information that we can gain from him. So it's with great pleasure that I invite Chris Stone to speak to us.
Well, thank you very much for that, and thank you all for joining this conversation. I hope I can use about half the time to describe work I've been doing and trying to follow up on that introduction, and then I hope we can spend some time talking together about the implications and how you see these issues. This is work, a culmination of years, decades of work in some ways, but also just the beginning of an effort to actually reflect back on what's really happened. What do reform prosecutors do when they actually get into office? What does change look like? What can it look like? And how do we know it when we see it? Let me just borrow that from the next panel. It's okay. There are few organizations in the world with greater, and fewer individuals in the world with greater reasons to distrust prosecutors than the African National Congress and Nelson Mandela 25 years ago. In the 1980s, prosecutors across South Africa sent tens of thousands of black South Africans to prison for violating codes and statutes of apartheid and its regime of white supremacy and oppression, and more than 1,000 to the gallows. And yet in the early 1990s, when the ANC negotiators sat down with the leaders of the apartheid government to negotiate a new democratic constitution, one of the ANC demands was a new, stronger national prosecuting authority. And the new democratic constitution of South Africa promised the creation of a new national prosecuting authority in 1996. In 1998, Mandela appointed Bulelani Ngoka as Democratic South Africa's first national director of public prosecutions, a lawyer who himself had been prosecuted and sentenced to 3 years of imprisonment for organizing a birthday party for Mandela when Mandela was still in prison on Robben Island. Moreover, Mandela and the ANC agreed to keep in office for at least 5 years all of the individual prosecutors, hundreds of prosecutors, who had been employed under the old regime to prosecute the ANC members and others across South Africa. Mandela, his Minister of Justice, Dullah Omar, and their chief prosecutor all understood that the new National Prosecuting Authority, even with its senior ranks all filled by members of the prior regime, would be a powerful force for justice, for rights, and democracy, and the rule of law. The ANC and Mandela could invest in prosecutors as engines of transformation of a system of injustice into a system of justice. If they could bet on the ability of prosecutors themselves to undo the prosecutorial arm of white supremacy, perhaps we should consider the same thing. 10 years earlier, when Margaret Thatcher was Prime Minister of Great Britain, she and her Conservative government were determined to increase police powers, including powers to stop and search. And they did so in landmark legislation still in place, known as the Police and Criminal Evidence Act. Skeptics were willing to go along with these increased police powers only if there was a separate reform agreed to check both the old and new police powers. And the reform agreed was the creation of the first professional prosecution service in England and Wales, the Crown Prosecution Service. Even today, few American lawyers and law students appreciate that, the long history of public prosecutors in the United States has no counterpart in Great Britain, or at least not in England and Wales, where the criminal courts relied from ancient times on private prosecution in the vast majority of cases. And in practice, by the 20th century, this meant prosecution by the police. When I first sat, as some of you may have done, before 1986 in a British magistrate's court, you would see not a professional prosecutor at the prosecuting table, but simply a bench of constables who had arrested various people the night before and who would stand up one at a time and prosecute the individual as their case was called. In the big jurisdictions, in London, Manchester, Birmingham, the police employed police solicitors who did that job. But the point was these were lawyers who worked for the chief constable, for the police, took instructions from them. And one of the reasons the Crown Prosecution Service was created in 1986 is this meant that no one could stop a police prosecution until the end of the submission of the case in chief, when a judge could actually direct a verdict of acquittal. But until then, no official could tell the police that this case should stop. The result, not surprisingly, was about 30% of cases by the mid-'80s were ending in directed verdicts of acquittal, because that was the first time anybody could stop these cases. And one of the goals of the Crown Prosecution Service was to reduce the number of directed acquittals by stopping cases earlier. The prosecution, it is literally true that the English system of public prosecution was invented essentially as a check on the police. Now, there's a tension in every prosecution service between being that check on the police or on other executive power and actually trying to prove cases which require a partnership with the police. I watched one of the training sessions for the Crown Prosecution Service in those early years in England, and they invited, before they'd thrown the switch and started the Crown Prosecution Service in 1986. They had a lot of training for these newly recruited prosecutors, and they brought the head of the National District Attorneys Association from the United States to deliver a lesson on how prosecution worked. I don't think anybody briefed Steve about what was going on in England. He was just invited to come talk about the American system of prosecution, and naively walked into a room full of literally hundreds of newly appointed Crown prosecutors and talked just about his work in Indianapolis and how it was as district attorney. He worked hand in glove with the police at every step of the way to put bad guys in prison. The effect was stunning. The prosecutors at the end of the presentation were completely, nobody applauded. People sat there in sort of stunned silence, and he began to realize something might have gone wrong in the presentation. He didn't, I talked to him later, he didn't quite know what was going on. And finally, one woman in the front, one prosecutor in the front row, I think visibly shaking, stood up and simply said, "Well, I guess the difference between your system and our system is you consider yourself a partner with the police." And she sat down. And I think he had no idea. I think he thought he was on Mars all of a sudden. I mean, I think it was this notion that prosecution could be so different, even in the country where so much of American common law and legal precedent comes from, I think was at the time almost unimaginable to American prosecutors. If Mandela and Thatcher government could both invest in new professional prosecution agencies to advance rights, to advance justice, to advance democracy, to reverse white supremacy, to check growing police powers, it at least suggests maybe we could try something like that here. I don't want to suggest that prosecutors are the solution to American criminal justice problems. We need police reform and a grassroots movement in every community in the nation to hold police accountable for their decisions and actions. We need reformed police chiefs. We need to change the faces of the victims' rights movement, recognizing that the modal victim of violent crime in America is a young man or woman of color, so that a congressional representative told she or he is meeting with the victims' rights advocates are actually expecting that face and not other faces to be greeting them in the room. We need to roll back the sentencing laws that mandate lengthy prison terms, and we need to expand access to legal assistance from charge to discharge. But perhaps the most important of all these, we have to change the culture of prosecution in this country. A culture that is out of step with professional prosecution in, I think, most other democracies, a culture that's rooted in the worst of American politics, a culture that undermines rather than supports the rule of law. My argument today is that it will take prosecutors, committed reform prosecutors, to do that. Now, I first made that argument in 2010 when I was at the running the program in criminal justice at the Kennedy School. And it seemed to me and my colleagues then that we had to think about a sort of 10-year project in culture change in American prosecution. Didn't know exactly how to do that. And then by happy accident, I was whisked away from Harvard by George Soros, who asked me to lead the Open Society Foundations. And that simply gave me an accidental opportunity one night at dinner to suggest to George that he use some of his political contributions in American politics to support prosecutorial races rather than federal races for Congress, Senate, or the presidency. And much to my surprise, he thought it was a great idea, and within a few weeks had hired essentially a talent scout to start traveling around the United States, trying to find people willing to take on races that largely seemed impossible. The number of contested incumbents who are challenged successfully in DA races is pretty small unless it is the deputy challenging the incumbent who somehow got a little soft during their first years or later years. These are, in American political terms, these are not expensive races, but they are races that attract relatively little attention and where incumbency is usually the beginning and end of the calculation. That beginning effort has grown today into a movement to elect reform prosecutors way beyond anything any one donor, George Soros or others, is doing. That movement now has the backing of numerous donors across the country, talent scouts, political consultants, trainers, and most important, voters in communities that have been repeatedly violated by the criminal justice system, voters in communities that are taking the ability to elect prosecutors, taking that ability up in new ways. Jed Sugarman at Fordham, a wonderful legal historian, has been writing about the rise of what he calls the political prosecutor in the United States, and how, in his view, the role of prosecutors in fueling mass incarceration and driving mass incarceration is connected to the changing political trajectory of prosecutors hoping for higher office. Others have been writing about the role of prosecutors in charging decisions, the use of discretion, and increasing the number and seriousness of charges brought as an explanation of mass incarceration. But the point isn't that politics inevitably drives that in that direction. The question we were trying to pose in this effort over the last few years is whether politics could work in the other direction as well. But even if you can do that, even if you are one of today probably 20, 25 reform prosecutors around the United States who who sought office on a platform of reform, who had an interest in changing the fundamental nature of the discretionary decisions made by prosecutors to change the culture of prosecution in the jurisdictions. Even if you wanted to do that, even if you found the backing to do that, even if you could win an election, how can you actually get that done? And as enthusiastic as I have been over the last decade about this idea, I also have spent most of my career trying to change systems of justice in this country and others, and it's really hard. They don't change very easily. And I've been feeling for these prosecutors who win these elections and then actually have to try and get this done. A lot of heroes, including Kim Fox, who was here yesterday, and what they are trying to do. But I spent the last few months visiting about 10 of these prosecutors who'd been in office for more than a year, sitting in their courtrooms, watching their assistants, talking to the supervisors, talking to the assistant DAs and state's attorneys, and spending a lot of time with the prosecutors themselves and the senior teams, trying to understand after a year, after 2 years, after 7 years, what can you actually, what's really changed. My worry was that they might be, like a lot of the liberal prosecutors from earlier eras, have decided simply to launch 1, 2, 3 reform initiatives that they run out of their office on good things, a victims' rights movement, something to do with sex offenders, something on drugs, but not actually change the daily machinery of prosecution operating in grand juries, in courtrooms, in offices. And that pattern of leaving the daily work of a prosecutor's office alone and launching a few high-profile centralized initiatives out of the DA's office themselves was a pattern that I'd seen a lot, and I think it can help on the margins. But what tends to happen is when the next DA comes in, they end that person's special initiatives, they start their own special initiatives, and the machinery carries on much as it has over the years. If you really, the prosecutors I was interested in were trying to change the machinery, trying to change what really was happening on a big scale. So having spent that time, I want to share with you sort of 5 lessons I took from what I saw in those offices. I'm not going to tie most of these to specific places. We can try and talk about that a bit. But this is political work. This is controversial work, and this is work going on right now. And so what I will, the jurisdictions I'm talking about here, I'll tell you the 10 of them. And I'm going to tell you some patterns of things I'm seeing, but I'm going to try and resist tying particular stories to particular offices. The 10 jurisdictions are Chicago and Houston, San Francisco, Albuquerque, Shreveport, Louisiana, Columbus, Mississippi, Henry County, Georgia, Orlando, Florida, Tampa, Florida. I think that's got them all. So as you'll see, it's a mix both geographically across the country. You have some very big cities, couple of the top 5 cities in the country by population. You have some really small counties and some 2 districts that are multi-county districts. You have a range of systems and some a range of political systems in which these prosecutors are working. And you have a variety of backgrounds. Some of these prosecutors are career prosecutors. They were U.S. attorneys. They were in prosecutors' offices before. Others are really new to this work. 5 lessons I take from these, and then we'll have a conversation, I hope. So there's a lot of really not fair, but a lot of easy stuff. There's a lot of, a lot of people are prosecuting marijuana possession a lot less. A lot of people are talking about diverting young people from the criminal justice system. Everybody's doing community outreach. None of those things, I think, are going to change the systems that or the cultures they're working on. They each have political appeal and appeal to various constituencies, but they're early things these prosecutors could announce. They talked about them in the campaign, and they thought they could do them with relatively little controversy. The bigger problem, trying to reduce substantially the numbers of people in the local jails, dealing more aggressively with police misconduct, to change sentencing patterns in the courts. Those seemed bigger problems, and one of the biggest problems in them had to do with the staffing in the offices. The smallest of these offices have 10, 11 prosecutors in them. The biggest have, as Kim's does, 800 prosecutors, and you've got everything in between. In some of the small offices, they literally did do what Kim said you can't do, and they just fired everybody. Not quite everybody, 9 out of 11 in one office. And those aren't all firings, but people decided to move on. That's a huge problem because, as in one of the offices, if all of your senior lawyers leave, and even if you can recruit new lawyers in, they won't have the experience and the knowledge that you've lost, and it can change outcomes, particularly if you have a hostile bench at the same time. And so there are jurisdictions where reform prosecutors lost a lot of senior staff and are noticeably losing a lot more trials. And even if trials are a small part of what they're doing, a hostile press, a hostile judiciary can talk about that a lot and really change the political dynamics for reform overall. So the staff problem, the challenge of a staff that has been there, has not been telling their friends, law school classmates, family members that their job is to do exactly whatever the elected DA tells them to do. They've been telling their classmates since they graduated from law school that they're an assistant DA. They make these really important decisions. They have tremendous discretion over whether people go to prison or not. This is why they love this job. They don't think they were doing the wrong thing for their careers. And so the fact that a new prosecutor comes in with a different policy or a different set of instructions, it's not as if that person is just going to switch what they're doing, change the way they exercise their own judgment. So the challenge of how to move the staff without changing everybody is probably the central puzzle each of these prosecutors faced. It's the same problem that my friend Bulani Ngoka faced in South Africa, of course. And I've always taken inspiration from the fact that he was able in South Africa to take this essentially almost all-white, long-standing prosecutorial service and turn the National Prosecuting Authority into a high-morale, highly functional, really into a service people wanted to be part of and felt really good about. The internal culture transformation in South Africa in the 1990s continues to inspire me about what is possible when you have a really gifted leader playing this role. The first thing Bulani did in South Africa is he went to visit with a lot of the press corps, the prosecutor who prosecuted him and sent him and the judge, together with the judge, sent him to Robben Island for 3 years. And in a highly public display, talked about his confidence in this person, how he was looking forward to working with them, how he knew that he was going to serve the new government. It was a brilliant piece of politics. One way or another, some of these reform prosecutors are finding ways of capturing the ambitions, the hearts, the commitments, the principles in their office. They're not doing it with everybody, and there are staff changes in every one of these offices, but they look very different office to office. Sort of come back to that in a moment. The crucial difference for a lot of these prosecutors is the role of supervisors in these offices. There are people with the title of supervisor in every one of the offices I visited. In some offices, they are supervisors in the sense that that's who you call if you're really in trouble, but they have a full caseload, they're doing their own work, and they're not sitting all day in court watching their supervisees and conducting training and coaching and collaborating with them. There are some offices where they look more like that, where they really are essentially full-time supervisors. They may do one or two, they may co-counsel cases with supervisees, they may participate in a couple of major cases, but they really are full-time supervisors. That is night and day a different tool for a reform prosecutor, if you have supervisors who are really able to supervise. And holding supervisors accountable for what their line officer, what the assistants in court every day are doing, is for some of the more effective reform prosecutors a really powerful tool for culture change in a way that trying to reach directly to every one of their assistants would not be. So let me give you an idea of some of the things, the sort of higher impact changes that even in the first year I was able to see in some of these offices. So in some, there's radical changes in how bail and pretrial detention is handled. In one office, literally an office that as a matter of policy never supported release on conditions in felony cases, is now never supporting cash bail in felony cases on the ground that they have no expertise in what bail amount would matter, and therefore they are simply either talking about conditions or seeking pretrial detention, but not advocating for cash bail at all. There are less dramatic changes than that, but in every one of these offices, changes in how pretrial detention, pretrial release, bail is being used is there. In many cases, in several of these offices I visited, the risk assessment tool being supported by the Arnold Foundation, which is often named the Arnold tool in these jurisdictions, is being used. It is proving controversial pretty much everywhere. Prosecutors who ran supporting it are finding themselves having to distance themselves from it in many cases. Usually it's not distanced completely, but trying to work in many cases with its designers to explain that it's not simply meant to replace the decision of the prosecutor or the judge or tell them the right outcome, but simply be a source of information and that can be considered along with others. The fact that it doesn't include assessment of the current charge and doesn't include juvenile past convictions as much as some judges and prosecutors think are relevant, have been particular flashpoints. But one way or another, the bail decisions, day in, day out, is a locus of real change in most of these offices. Sentencing allocution is one of the biggest surprises I had. I sat in one courtroom, and I didn't go to trials. I wanted to see pleas. I wanted to see sentencing hearings. I wanted to see arraignments. And the sentencing hearings were, in one jurisdiction, a real complete surprise. Sentencing allocution after sentencing allocution, I sat there and I watched these assistant DAs who were really good. I mean, they might have just come off arguing a motion, a post-verdict motion, or doing a plea allocution really superbly, technically well. And then the question would come for sentence, and they kept saying, we trust the decision of the court, and said nothing. No sentencing allocution. And it happened once, and then it happened again, and then it happened again. Then a child sex case came up, and it happened again. And I thought, this is unbelievable. In Britain, prosecutors don't go to sentencing hearings because they don't think it's the job of the prosecutor's job is to make sure the case, the justice is done and the evidence comes forth and they get the right answer. And sentencing they leave to the defense lawyer and the judge with a report from the probation service. In fact, around the world, very few prosecutors' offices think about sentencing as their professional work. In this country, of course, it's exactly the opposite. And so to sit in a southern courtroom and see in a pretty conservative jurisdiction, see these prosecutors essentially not take advantage of the opportunity to allocute on sentencing was stunning. And when I asked the prosecutor, I was so surprised, I asked the judge, I went back and talked to the judge afterwards in this case and asked him what he thought was going on here. And he said, you get a pretty good sense from the case, even a plea allocution of what they think about this case. And I don't feel this hurts my ability to deal with these matters really in any significant way. And when I talked to the elected prosecutor, he just said he thought that he said when there are factual matters they think the judge needs to consider as part of sentencing, they'll bring them up, but they do not want to intrude on what they see as the appropriate role of the court. So sentencing, again, I'm giving a couple of extreme examples. That was not matched anywhere else, but the rules about how the office is going to speak to questions of sentence, I think is a second big area. Plea policy, obviously, you have probably the most radical version I've seen anywhere in the country is what's going on here in Philadelphia. But I was focused not on newly elected prosecutors, but people who've been in at least a year. In plea policies, it was much harder. Here, the focus, mostly what I saw, was efforts to try and get supervisors to talk with assistants to get them to explain why they were offering various pleas. It was really trying to move off a kind of rote or traditional. Kim Fox talked a little bit about this yesterday, trying to re-engage prosecutors about how they thought about pleas, what they were trying to do with plea offers, why they were offering the pleas they were doing. In some cases, in small offices, I watched the elected DA just sit down with a senior attorney and just go through a docket and go through a week's worth of or a day's worth of plea offers and trying to get them to understand what they were doing. In others, it was about training supervisors to do much the same. But of all the things I saw, the thing that excited me the most and the thing I was least prepared for was in 4 of the 10 jurisdictions, DAs, the elected DAs, had changed the policy of indicting on felonies. And they'd changed it from indicting, whether it's a grand jury or their own information, they changed the policy from probable cause to beyond a reasonable doubt. So in 4 of the 10 jurisdictions I visited, and they're talking about this policy, the DAs changed and said, we will only indict if we have evidence beyond a reasonable doubt for each of the charges we're indicting on. Now, that, in one jurisdiction, I talked to the grand jury judge, and he told me we used to hold grand jury 4 days a week. We're down to a day and a half. And he thought it was great. I talked to a police detective, head of detectives in one jurisdiction where this happened, thinking he was going to think this was indictable conduct. He said it's making our detectives better. There's 2 stories in that. One, I was stunned anybody would do this. It hadn't read about this, hadn't heard about this as a reform policy. It has huge implications, as the days of the week of the grand jury illustrates, but it was being done by some of the most politically savvy of these elected DAs. The fact they were doing it and they had the support of the court, and they had, or the support at least of some senior police, was itself as important as their decision to try and make that change happen. As one of the elected DAs said to me, when I was still, I think the second jurisdiction I saw this happen in, I said, "This is unbelievable. How are you talking about this? How if you've always indicted on probable cause, how are you explaining this?" And he said, the police come in and they'll typically say, "Yeah, okay, so, we can't prove this at trial yet, but we're going to keep investigating, and, the case is going to get stronger." And he said, cases don't get stronger after grand jury. Cases get weaker after grand jury. That if we can't prove it beyond a reasonable doubt in the grand jury, we are not going to be able to prove it beyond a reasonable doubt at trial. As an ethic in the office, it has huge implications. One of the prosecutors explained to me, he said, what they're doing is the police come in, they say, well, we know who did it. We can't exactly prove it all. We can prove these things. We can't, we have enough to indict on this. But maybe you'll take a plea. Maybe, it's leverage, and it's explicitly leverage right at the beginning. And these four prosecutors would immediately say on that, said, it's not ethical. It would say, if we don't think we're going to be able to prove it beyond a reasonable doubt, and we're just doing this for leverage, that's not ethical. That's not the law. That's not what prosecuting attorneys should be doing. And it extends beyond that. Some of them would say, in fact, these officers were taking pleas on cases they knew they couldn't prove. Because they'd indicted them, there was enough leverage, the person agreed to plead to one of the charges, and they're taking pleas on cases where they don't think they could have won the trial. And by raising the stakes for the attorneys, the ethical, the legal stakes that way, they're trying to shift a culture to only pursuing charges from indictment on in felonies where they have evidence beyond a reasonable doubt. It's not popular everywhere. I gave you two examples where there were support from the bench and support from the police. There are jurisdictions among those four where this is hugely controversial and has at least some of the police and judiciary quite upset. But the fact that in four of the 10 jurisdictions it was happening struck me as significant. I think the thing that's rare, I think the big area where these prosecutors are struggling the most is they feel that their liberal or some of them would just say on the left constituency is always unhappy that they aren't going farther than they're going in a reform agenda, but that no one and they have lots of offers of help on how they can ask for pretrial detention less often, how they can prosecute fewer crimes, how they can divert more people. But how to help them with rising violent crime, all of a sudden nobody's in the room helping them. And the absence of assistance and reform strategies for dealing with increasing violent crime, serious murder cases, shootings and killings of police officers, all of a sudden the left liberal constituency has a lot less help on offer. There are some offices that are looking for ways of balancing their story about reducing the numbers of prosecutions, reducing the number of people in jail, with stories about aggressive prosecution. The newer prosecutors want to talk about community safety. And they know they're walking into a trap because the data they're using to test whether they're improving community safety aren't data they control. They're actually counting on the crime data that gets reported. So they're betting that they'll get lucky, and that violent crime won't go up while they're doing this other stuff. And of course, it is going up in some of these jurisdictions. And they're, I think the prosecutors in just for a year or a little more than a year are struggling over how they talk about that and how they think about what their office can really do about it. Even if they believe that good prosecution can change the frequency of some crimes, and very few of them are, I think, willing to really bet a lot on that. They would all say, even those prosecutors would say they know there are other factors that could swamp what they could do in their office. A change in the price of heroin, a change in the closing of a major employer, those kinds of things. Even if their prosecution is doing helping on issues of crime, can have much more effect in their communities. So I think what some of the more interesting prosecutors and and this is generally those who've been in longer than a year, are doing is figuring out how to develop a public narrative about new forms of really creative, aggressive, complex prosecution. So what they're doing is bringing fewer minor cases, and they're talking more about more interesting, complicated investigations. The single topic that was most politically popular with the prosecutions is much more aggressive, longer-term investigations, serious charges in human trafficking. And I was, again, not anticipating this, but in the same way that I watched in New York City in the early 1990s during the first years of the Giuliani administration in New York, watched police departments trying to focus on gun crimes by debriefing people charged with possession of guns, doing non-Mirandized, non-evidentiary interrogations. Somebody gets picked up, they're possessing a gun. The police in New York before Bratton came in 93, 94, would have just charged that case as possession. They had the evidence. They didn't need a confession. They started routinely interrogating people about where they got the gun. And they didn't use Miranda because they weren't intending to use any of the statements as evidence, so they didn't bother Mirandizing anybody. That same technique is being used in sex work. So in multiple of these jurisdictions, being led by the prosecutor, not by the police, they are charging fewer sex work cases, and they're not asking for detention. So there's reform in sex work in a lot of these jurisdictions. But the more interesting thing going on is much more engagement with people involved in sex work about the networks in which they are participating. And that's leading to some more complex cases in human trafficking. But let me give you a different example, because I think while human trafficking was the crime category that came up across a number of these jurisdictions, the more interesting and the more successful, I think, of these efforts to demonstrate affirmative crime-fighting record for the DA were picking local issues that were really resonating and doing something really creative about those. Give you one example. This I will identify from San Francisco because it's been in the press a lot. There was a phenomenon I wasn't aware of in San Francisco called flash robberies. A flash robbery, if you aren't familiar with the term, involves a group of people go into a retail store and it's like the old shopping sprees. They just empty the shelves. They've got big buckets. They're just taking everything off the shelves and leaving. It's a very brazen, very big sort of concerted effort. And there were a few of these in San Francisco. The prosecutors worked with police and with merchants not just to try and deal with individual ones of these, but to try and actually figure out what the networks were that were supporting and I mean, the nice thing about these is there's a lot of goods you've got to fence at this point. So there's it has the shape of much more organized crime opportunity, a kind of investigation. And yet these weren't the kinds of cases that would come to the attention of the serious organized crime task forces in different jurisdictions. So the San Francisco DA's office did a series of cases on this, but ended up coordinating with DA's offices in at least 2 other states, tracking down networks that were involved in these flash robberies and making a fairly big deal out of it and getting a lot of credit for it. The point is, I use that example because what they were doing was using essentially more sophisticated prosecution techniques, investigative techniques, on patterns of cases, whether it's the human trafficking or the flash robberies or other kinds of cases. These DAs were saying we can provide safety by looking at big pattern cases and going after the organizations and structures behind the patterns rather than deal with the sort of retail effect of the patterns. I had a teacher once who used to had a line I always liked, that all crime is organized crime. And his point was even the 14-year-old who breaks into the neighbor's house and takes the television depends on there being some place to sell that television, and that's connected to some organization. The prosecutors who are looking for patterns, looking for organization in the what otherwise might be minor cases, is that I think that's something that's going on in a lot of these reform offices. I'm going to wrap up in the next 3 minutes here. I'll see if I can get back to this. The last thing, so some easy stuff, some staff changes, these sort of big real changes, bail, sentencing, pleas, felony charging threshold, aggressive prosecution of serious crime patterns, human trafficking, flash robberies. But the 5th thing I want to talk about is culture change and how these prosecutors talk and how they're trying to reshape the culture of their offices. They're all trying to do. I think the things that were working least well, as Kim Foxx was saying yesterday, are trying to change the culture by issuing new policies. The prosecutors I saw after a year, 2 years, who were struggling the most, who didn't trust their executive teams, who were convinced people in their inner circle were planning to run against them the next time, were the ones who were relying more on directing people in the office to change what they were doing through new policies. So what are the alternatives in culture change? I think if there's a pattern of what I saw, it's about prosecutors doing what Kim Foxx was talking about yesterday, essentially saying, I'm trying to get you back to your best selves. I'm trying to give you the space to practice the way you always wanted to practice, and not, you've been doing this wrong, and now you have to do it my way. And so using devices, Kim Foxx talked yesterday, I thought brilliantly, about using the oath that prosecutors give. A different prosecutor said, a line prosecutor in an office that is, I think, changing pretty effectively, said, the biggest change the DA has really brought is with our relation with defense lawyers. They hated us, we hated them. The talk in the office, the contempt for defense lawyers in this office over the years was really uncomfortable. It was really kind of an unpleasant feeling. And the attitude, the DA's attitude is really, we all have important missions. We're all trying to work for justice. We're all trying to represent, we're all trying to uphold constitutional rights. Those are important issues for them. But in the end, we're all attorneys first. And that phrase, we're all attorneys first, is an effort to change a culture of open warfare into a culture grounded more in integrity. It's not that different from Kim Foxx's use of the oath. One of the prosecutors who had changed the standard of indictment at grand jury to beyond a reasonable doubt, found the communities, the phrase I heard in one of these offices along those lines, an alternative of the good against evil one, was another piece of just common sense. One of these prosecutors said, you know, my grandmother used to tell me there's good and bad in everybody. And that's the ethic we're trying to, that's the understanding of the people we're prosecuting, both the victims and the community members and the defendants that we're dealing with. It's in language like that. It's in common sense language. It's in appeals to the law. It's appeals to the profession that I think the culture change I was seeing was most successful. So let me stop there and see if we have a little time for some discussion. We talked a little bit yesterday about the politics of criminal justice in a context of fear and the problem of a politics of fear driving a lot of bad decisions in criminal justice policy. I think the more successful of these reform prosecutors are taking on that culture directly and trying in their public statements and in their and in the work of the office to change a culture of fear into a culture of hope. But that's political work. That's trying to deal with people's sense of safety, sense of justice, sense of how the system is working and the values of the system directly. The question of how their prosecutors are exercising discretion on bail cases. Let me stick with that example I was using before, trying to say, if you don't have a basis, you don't have a professional basis for picking one number versus another number for amount of money for money bail, then it's easier to explain to the prosecutor we're not going to speak to the question of money bail. You can do that as a principled matter, and then you can set a series of expectations for different offenses about where the expectation would be you're going to ask for release on conditions. If you want to ask for detention, you have to be able to explain it to a supervisor. I mean, it's about encouraging reasoned decision making and reasons for discretion, but it's not trying to give them the idea that they have to have in their mind a particular voter every time they're exercising their discretion. I'll give you another example. We talked yesterday about many of these prosecutors, they talk explicitly about trying to change the culture. Some of them, about half of them, talked about it as culture change. Others would talk about, usually this phrase kept coming up, mindset. The mindset in this office is about winning, or the mindset in this office was about long sentences. The culture of winning is tricky, right? Someone was saying yesterday on one of the panels that people get promoted by how many convictions they have or by going to trial and winning. So in one of the offices, they're trying to say, you're not going to get promoted if you don't go to trial, but you're not expected to win every time. And trying to hold on to the going to trial part, but separate it from the question of winning and losing, it's at that level that most of these prosecutors are trying to talk about discretion, decisions that the individual assistants are making. And the ones who are succeeding, you talk to the assistants in the office, and the reason they say they like the changes is they're getting to practice, they're getting to be like real lawyers. And they've developed a narrative. I'm not sure it was there under the old regime, but their new narrative is the old regime had actually too many mandatory policies, and they have more discretion under the new reform prosecutor than they had under their predecessor. So it's about pride in their own professional authority that these new prosecutors are trying to capture.
But it sounds like some of that pride and some of that discretion is being driven by principles as well, so that in lieu of taking away all your discretion, what we're going to do is we're going to have clearly articulated principles that allow you to then apply your discretion within ways that advance the kind of attorney you always wanted to be when you took the oath.
There you go, something like that.
So we got some great questions. I don't know if we will have time to get to them all, but let's see what we can do. One of the questions from the audience is, what learnings have you or the Open Society Foundation or George Soros taken from funding some of these races as we come into a new election cycle? Are there things that you would do differently or ways that you would make that more efficient or useful?
There's a lot there. Let me just pick a couple of things. So one is the fact that whether it's George Soros or one of the other big donors from outside the jurisdiction are funding are providing funding during these elections became an issue in a lot of these cases, in a lot of these races, and it almost never mattered. So the people who were opposing the reform prosecutors tried to make a lot of this outside funding. And for people who didn't like the reform prosecutors, that worked, but it didn't seem to change votes. The people who wanted the reforms didn't care where the money was coming from, and the people who were opposing them may have been strengthened in their opposition through this, but it didn't seem to affect outcomes. So I think there's staying focused on helping the candidates stay focused on the issues and not really worry about the fact of the changed financial landscape is one piece. I think there were there is a constituency that there's a difference between what the DA who's running ran to do and why they get elected. So I'll give you an example. In one jurisdiction, there's a DA who ran really out of a belief about mass incarceration, and talks very powerfully about why changing that, reducing mass incarceration is what that DA really wants to achieve, but got elected because of a bad police shooting. The energy in the community that supported this DA was really mobilized by a scandal over a fatal police shooting, not particularly. So managing those two issues, trying to figure out how much is that DA going to focus on trying to change the prison and jail population versus what they're going to do around the police issue becomes a really important tactical strategic question, but also one about their own, who they are as a prosecutor, what they represent, what their message is about the change they're trying to bring. Most of these, maybe every one of these 10 knows they won't succeed if they don't get reelected. That if they are one-term prosecutors, whatever they do, Kim said it yesterday, will be taken out. And so they're all thinking about a long game, whereas most of their supporters are thinking much more short-term. And so whether it's balancing the constituency versus their own commitments, or whether it's trying to balance a long-term strategy with a short-term strategy, they're trying to navigate a series of priorities that the election doesn't answer and that the reform agenda doesn't answer.
And was there a way, it seems one of the things we talk about at the Quattrone Center when we talk about a systems approach is that upstream and downstream constituents affect the way you act in the system. So as you said, the need to work with police on one hand, but also be an oversight agency dealing with police on the other, the need to work with the judiciary, with the defense, and build those partnerships. And when the public defender issues a new policy or the judges take a particular stance, that affects the way you have to act as a prosecutor. In your evaluation of candidates, yours, plural, obligation of candidates to back in these elections, Was that something that you tried to identify? Was the ability to operate effectively as a change agent with other agencies? Any learnings there on how to identify that in a candidate?
So I didn't participate in
That's why, yeah, you plural was key.
decisions about who to back. I think and there were real debates. I think there's no question that the political skills, the change management skills, the institutional leadership skills of the prosecutors who were elected crosses a wide spectrum. You've got some very, very talented, extraordinarily talented politicians who also are very talented lawyers, and you've got others who are know when they ran, are really principled, or really want to do the right thing, but they are in their first ever experience trying to change an institution, do that kind of management work, that kind of leadership. And you know, if you'd want more experience there if you could have it, but I actually think the more important quality in the candidates is whether they are how fundamental, how radical, if you will, in the literal sense of radical, they want to make change. I will tell you, this is just a personal reflection, not necessarily representative of anybody else in this movement. There's a lot of defense lawyers, and there were a lot of civil libertarians and a lot of just liberal political activists who think the most important thing to do in this moment of reform prosecution is challenge the toughest, worst prosecutors in the country. Prosecutors who are responsible for the most death penalties, the prosecutors who are the most hostile to the defense bar, who are the worst of the worst in the sort of nightmare prosecutor. I was never enthusiastic about those challenges, not because it isn't important in those jurisdictions, but the way you beat the worst of the worst is with the middle of the road. It would be crazy to run a real reform prosecutor against in a jurisdiction where what they've been electing up to now is the worst of the worst prosecutor. The way you're going to win that race is with someone who's going to go right down the middle. And the American system of criminal justice that we've got, mass incarceration, all the rest of it, is the product of right down the middle. Those are the prosecutors who got us where we are. And so for me, the more interesting thing is Soros, the Open Society Foundations, I had nothing to do with the race in Brooklyn, New York, when Ken Thompson challenged Joe Hines. But Joe Hines had a reputation as a liberal prosecutor, and it was only by challenging him with someone like Ken Thompson that you were going to get real change in what was going on in Brooklyn. And so to me, the opportunity, the important thing right now is to be looking for people who have a vision of real fundamental change, who want, as one of the prosecutors I visited said, you know, I asked them all sort of, what's your vision of success in 10 years? One of them said, oh, I know absolutely. It's our local jail will have 30% or less of the population it has today. Not half, not 10% reduction, not a 20% reduction. I want a 70% reduction in the, I don't know why they had that number. That's a huge change. And you need people who are ambitious at that scale, who want to see that big a change in whatever dimension. It doesn't have to be on the jail population, can just be in the culture in the office. But you want people who are really determined to take on the real system, who are not just trying to curb the excesses of a particularly vindictive prosecutor.
Last question, and I think we will have to break, unfortunately, because I could do this all day. Have you noticed any pattern in judicial acceptance of reformed prosecutors? And is there anything that the more successful ones do to engage the judiciary?
Yeah, they engage the judiciary. I think you can't. I think it's just a fundamental difference between public and social causes and for-profit businesses. And the for-profit businesses strategy is all about winning when others lose. The modal, there's competition and collaboration in every sector, in every form of organizational life, but there are some where the modal way of working is competition, and others where the modal way is working as collaboration. But if you're going to succeed on these big public goals, if you're going to work on issues like justice or health or education or poverty, you know one organization is going to achieve what needs to be achieved. You're only going to succeed if multiple organizations are succeeding at the same time. And so I think the people who impressed me most, the reform prosecutors impressed me most, were building relations with reform police, reform judges. They might be mavericks even in their own organizations. They were finding collaborators in other agencies from day one, from before day one, and they were trying to figure out how they could help them, and recognizing their particular strengths and weaknesses. So, the people who were in most trouble didn't have those alliances, and it's not just with the other agencies. There's more than one jurisdiction I visited where I was told, yes, there's a mayor and there's a council and there's the county officials and there's the governor, but the real power in this town is this club of the biggest businesses that get together and the CEOs that meet every month there. And there are reform prosecutors who made sure they were speaking at that breakfast meeting in their first 2-3 months, and there were prosecutors who a year or 2 years in knew that group existed, but hadn't even thought it was a priority to get in front of them. And so it's not just about the judiciary. It's not, the bar is also the bar, the judiciary, state officials. It's not that you have to become just a retail politician, but there is a sort of political sense and a political side to this work that you can't ignore.
Well, it's a little known fact that we tried to get you here 5 years ago to speak at our inaugural conference, and this is why. It's a delight to have you, and thanks very much for your time.
Thank you all.